Everyone, welcome back to another video. I, Shrishti Mishra, legal attorney, LEXCLIQ and Company, is going to present today's video topic, that is difference between tort and breach of contract. Before just moving ahead with the topic, it is very important to know that this video does not solicit any kind of promotion or advertisement under the guideline of Bar Council of India. Sole purpose of this video is only for education purpose. Now let's get started with the video. So here, difference between tort and breach of contract. So there are some points which I have listed down. So first point, starting with tort, that is tort occurs when the right given to all the person, all the individual is violated, okay, and without the existence of any contract. So here means that everyone has their personal right, and if that right is violated by any of them, any of them, so in that case tort arises. For instance, if I say that at late night where some party is going on, loud music are on, and due to which you are at home studying for your exam, for next exam, and in that case you're not able to concentrate in your studies just because of that loud music. So in this case, what happens that the right of a person, the right of individual is violated, and here tort arises, tort occur. Now talking about breach of contract, that is the breach of contracts occurs due to the breach of duty, okay, agreed upon both the parties. So when the contract form is made, contract is agreed upon by both the partners. So in this case, what happens that if while agreement takes place, both the parties writes their duties, responsibilities. If in case some unreasonable thing happens, what are the compensation provided to that victim, everything for both of them are listed down in that agreement. So if the duty is breached, if the duty is not done by any of the person, any of the parties, so in that case what happened, that breach of contract take place. Now talking about another that is another head, that is another difference. So first, tort, damage are always कभी कभार नहीं, always they are unliquidated, so the victim is compensated by the judge. Here unliquidated means they are not pre-decided. This means पहले से what are the compensation is not decided. It's not pre-decided that in this case 10,000 or in that case 20,000. No, this is not done. When some case arises of tort, in that what's happened that if compensation is to be provided to the victim, it is pre-decided that unliquidated, and judges the victim is compensated by the judges. Judges decide what is the amount of compensation to be paid to the victim. Now talking about breach of contract, so victim is compensated as the terms of contract and the damages are usually liquidated. So here I told you above that all the agreement form is made before entering into any contract, any agreement. So in that only if some unreasonable things happen, so in that case the parties write the compensation amount, that if something unreasonable happen, this is the amount to be paid. So this is liquidated, pre-decided, पहले से रहते हैं what is the amount to be paid as compensation. Now another point, that is another difference, talking about first is tort. So duty is fixed by the law of lands. So duty is fixed. It means that tort is a civil wrong, where if personal rights are violated, then only tort take place. Nahi, if someone personal rights are not violated, in that case no tort is arise, no tort is made. So this is about tort. Now talking about breach of contract. So duties is fixed by the parties entering into contract by themselves. So as I told you above, that duties are pre-mentioned in the agreement that are written by both the parties. Now talking about another point, another difference, that is first tort. So doctrine of privity of contract does not apply here as there has been no contract. So talking about doctrine of privity, when two parties came in contract, when two parties agreed to come in contract and any unreasonable thing happened, in that case both the parties can sue each other. So I repeat that if some unreasonable things happens among the parties, among where the contract is going on, and in that case what happened, that some unreasonable thing happened, and in that case both the parties have right to sue each other. And in tort, talking about in tort, so there is no contract, कॉन्ट्रैक्ट होता ही नहीं दो पार्टीज के बीच, ओनली समवन पर्सनल individual right is violated, then tort occur. And so this is not there, doctrine of privity does not apply in tort. Now talking about breach of contract. So breach of contract में what happened, that doctrine of privity of contract is applied because there is an agreement between the two parties, and in that case if something unreasonable happen they can sue each other. Now last point of difference is that tort apply even in the cases where the contract is void, and for example a minor contract. So tort वहाँ भी अप्लाई होता है where the case are void अब in issue where the case is void, still the tort can take place at that time, compensation is provided in that case. Now another point, last point of that is breach of contract. Where a contract is void, then there is no question of compensation. So if the contract is void ab initio, and in that case of course, in that case what happens, that question of compensation does not arise if anything is going illegal, and in that case someone asks for compensation, that then no compensation is arise. And for example is that minor contract, we know that minor contract is void, and in that case if compensation की बात अगर उठती है, in that case no compensation is provided. So this is whole about this topic, that is difference between breach of contract and tort. I hope you find this video useful, and if you find this video useful, go and smash the like button, subscribe to our channel, and let me know your feedback in the comment box below down. Till then, take care, goodbye.